Donald Trump may have had a tenured law professor testify, but all that testimony has demonstrated is that for $1 million, some experts will just say whatever you want them to say. I'm Ben Meiselas from the MeidasTouch Network, and those words came from a scathing order by New York Justice Arthur Engoron, who's presiding over the New York Attorney General's civil fraud case. Donald Trump has moved for what's called directed verdict over and over again. The most recent time moving for directed verdict to try to get the case dismissed was before Judge Engoron, following the testimony of Eli Bartov, that tenured professor who Justice Engoron did not think very highly of. And Justice Engoron once again denied Donald Trump's motion for a directed verdict, and now goes to the next step, where closing arguments will take place in January before a final order is released by Judge Engoron on the remaining causes of action. You'll recall that Justice Arthur Engoron has already found the Trump Organization, Donald Trump, Don Jr., Eric, and others liable for their conduct. He's already ordered the dissolution of the Trump Organization and the various entities under the revocable Trump Trust. Now we're talking about disgorgement damages. I've predicted before, and I'll predict again, that will at a bare minimum be $500 million and likely more. Now, one of the other key things in this ruling by Justice Engoron denying Donald Trump's motion for a directed verdict went to the fact that Justice Engoron keeps pointing out to Donald Trump and Trump's lawyers, you clearly, one, either don't understand what this case is about, but more likely you're just gaslighting the public and doing this to waste time. Because what Judge Engoron says is, look, I concede that there are many different ways that you can come up with valuations, but that's not what this case is about. What this case is about is a lie, and you, sir, are lying, Donald Trump. And here's what Judge Engoron writes. He says, valuations, as elucidated ad nauseum in this trial, can be based on different criteria, analyzed in different ways. But a lie is still a lie. Valuing occupied residences as if vacant, valuing restricted land as if unrestricted, valuing an apartment as if it were triple its actual size, valuing property many times the amount of concealed appraisals, valuing planned buildings as if completed and ready to rent, valuing golf courses with brand premium while claiming not to, and valuing restricted funds as cash are not subjective differences as opinion. They are misstatements at best and fraud at worst. Then Judge Engoron states in the very opening that at least 5 times during the recently concluded 10.5-week trial of this matter, defendants, Donald Trump and others, moved for a directed verdict. The first such time was at the close of plaintiff's case, which is when defendants normally move for such relief. This court took that motion and most of the others under advisement. It denied 2 of them on the spot. At the close of plaintiff's rebuttal case, defendants requested permission to move, yet again, pursuant to CPLR 4401 for a directed verdict. Plaintiff opposed the request, not wanting to impose an undue prior restraint. He's mocking Donald Trump there. Not wanting to impose an undue prior restraint, because Donald Trump keeps saying that he should be able to just say or do whatever it is that he wants to do without any gag orders being imposed. So it's a slight little jab there by Judge Engoron, if you sense his sense of humor. Not wanting to impose an undue prior restraint, this court granted the request. The instant letter motion ensued. This court hereby denies the motion and furthermore denies all prior motions that the court previously took under advisement. The court puts in a footnote. One such motion came immediately after the close of testimony of Michael Cohen, whom defendants wishfully denominated plaintiff's star witness. In denying that motion, this court noted that the evidence of wrongdoing already admitted into evidence was voluminous. And there the court's just making clear, not just to the parties before it now, but to the appellate division and later to New York's highest court, the Court of Appeal, that Donald Trump's representations of what Cohen meant to this case, just because Donald Trump says it so, isn't the case. And you don't move for directed verdict when things like that happen. It goes on to say, rather than marshal and detail yet again the evidence support of plaintiff's prima facie case and defendant's failure to do more than raise issues of fact, this court will highlight some of the fatal flaws in Donald Trump's instant motion. The most glaring flaw is to assume that the testimony of defendants' experts, notably Jason Flemings and Eli Bartov, is true and accurate, or at least that the court, as the trier of fact, will accept it as true and accurate. Bartov is a tenured professor, but all that testimony proves is that for $1 million or so, some experts will say whatever the heck you want them to say, whatever you want them to say. His overarching point was that the subjective statements of financial condition were accurate in every respect. As this court discussed in excruciating detail in its September 26, 2023 summary judgment decision, the statement of financial condition contained numerous obvious errors. By doggedly attempting to justify every misstatement, Professor Bartov lost all credibility. All credibility. For $1 million, Bartov lost all credibility. And when you think about it, every time there was something that was fraudulent, Bartov would say, oh, that's an error. And it can't be fraudulent if it exists on the financials because people try to conceal fraud. And there the court's just saying that absolutely makes no sense at all. Then it goes, Mr. Flemings acknowledged that he had never valued property, much less was he a valuation expert, but he attempted to opine on values. The crux of Mr. Flemings' testimony was that so long as defendants selected one of the methods that the accounting board permits, then any numbers may be entered into such methodology, regardless of their accuracy or relationship to reality. Mr. Flemings also inexplicably acknowledged that future income had to be discounted to present valuation on a financial statement, while at the same time stating there were no generally accepting accounting principle departures where defendants failed to apply a discount rate to future income. He opined that Meiselas should have followed up on items in the statement of financial conditions, but then stated adamantly that it would have been highly unusual for Meiselas to make an inquiry for any appraisals in the client's possession. He was reluctant to acknowledge that an asset controlled by a third party cannot be considered cash, while also acknowledging that it was a red flag. Defendants persist in arguing that if a loan closes prior to the period during which the statute of limitation allows suit, then any required follow-up statement of financial condition made during that period is somehow sacrosanct. The contention is belied by a plain reading of Executive Law Section 6312, by the law of the case doctrine, and perhaps importantly by common sense. Closing is not a get-out-of-jail-free card for future misstatements. All that Section 6312 requires is a false statement used in business. The subject financial statements fit that definition to a T. You can't go back and say because you closed a transaction in the year 2000 or in the year 2010 or in the year 1995 that closing immunizes you from using those financial statements in the future to commit fraud. That's where Judge Engoron says that makes no sense. I could give you the law, I could give you the statutory analysis, but that just makes no sense. And then Judge Engoron goes on to say what I said at the outset, that yes, we've heard that there are different ways to do valuations, but at the end of the day, what this case is about are the material misrepresentations and outright fraud that precedes the valuations. That when you say a property is completely occupied and it is vacant, when you say that you have a residential property but it's a commercial property, when you say that some of your other properties have whatever the special feature is, but in reality, those things don't exist. When you say that you have a triplex that's 30,000 square feet when it's 10,000 square feet, when you do this same scam to all of your properties, that's not using a different valuation methodology. That's a lie. And a lie is a lie. So the directed verdict motion, the motion to dismiss, is denied, but a very scathing order there by Justice Engoron. I could only imagine what Judge Engoron's final order is going to look like after closing arguments in early January. We will keep you posted, but expect a $500 million to $1 billion judgment against Donald Trump before February. I'm Ben Meiselas from the MeidasTouch Network. Hit subscribe. We're on our way to 2 million subscribers thanks to your support. Have a great one.
Thanks so much for watching. We're only a few subscribers short of 2 million subs. Please subscribe right now to the MeidasTouch YouTube channel for free and help us grow this unapologetically pro-democracy network.